Hello everyone, welcome to the Public International Law course. We will continue our course with Chapter 5. In this chapter, we will talk about the concept and principle of state jurisdiction, the basis of jurisdiction, sovereign immunity, immunities of international organizations, and lastly, diplomatic and consular relations. Today, we start with the concept and principle of state jurisdiction. As a rule, every state exercises exclusive jurisdiction within its own territory. However, international law does not put any limitation on the state's power to exercise jurisdiction beyond its territorial limits. When a state exercises its jurisdiction beyond its territory, it is called extraterritorial jurisdiction. Restrictions upon the independence of states cannot be presumed. It is true that there is no restriction on a state's jurisdiction. However, states generally do not exercise jurisdiction over acts with which they have absolutely no concern. The territorial basis of jurisdiction normally is the starting point in this matter. In criminal matters also, the substantial connection between the alleged offender or the offense with the state exercising jurisdiction is necessary. In matters of civil jurisdiction, the municipal courts apply private international law in those cases where a foreign element is involved. Let's move on with the basis of jurisdiction. The power of the state to exercise jurisdiction over persons, property, or events occurring with its territory is conceded by international law. All persons present, even transiently, and incidents occurring therein are amenable to the state's jurisdiction. The obvious reasons for the exercise of territorial jurisdiction, particularly relating to criminal law, are that the state where the crime is committed generally has the strongest interest in punishing the criminal. The local forum is the most convenient one since the witnesses and other facilities are most probably available there. The offender is most likely to be found there, and to avoid the element of double jeopardy. A state may exercise jurisdiction on the basis of the nationality of the person. The person concerned is its national who has either committed the crime or is the victim of the crime. The jurisdiction may be exercised on either of the two grounds, the active nationality principle and the passive nationality principle. Now let's look at what sovereign immunity is. Under international law, certain degree of exemption and immunity from local jurisdiction is enjoyed by foreign sovereigns and foreign states, foreign public ships, foreign armed forces, international organizations, diplomatic representatives and consuls of foreign states. The concept of sovereign immunity is a principle of customary international law. A foreign sovereign or state is not amenable to the jurisdiction of the state of the forum unless it voluntarily submits to the jurisdiction of the local courts and the law enforcement agencies. However, there is no bar against the foreign sovereign initiating the proceedings in territorial state. The concept was earlier attached to the person of the sovereign, but later extended to the state and its organs. The two terms, state immunity and sovereign immunity, are oftentimes used interchangeably. The person of a sovereign is exempt from arrest or detention within a foreign territory. This exemption extends to the foreign troops, the diplomatic agents, and other representatives of the foreign sovereign. The legislative, administrative, and executive acts of the foreign state and its agents cannot be called into question by the territorial state. When we look at the current legal positions, recent developments in the field of sovereign immunity in many jurisdictions have indicated a trend of restricting the sovereign immunity to governmental activities of public nature and not to commercial activities. However, these developments are mainly confined to Western countries. The majority of the developing countries still adhere to the rule of absolute immunity. some countries have adopted legislation giving effect to the rule of relative immunity, such as the USA, the UK, Australia, and Canada. Now we should talk about immunities of international organizations. International organizations such as the United Nations, the International Atomic Energy Agency, and the International Monetary Fund also enjoy certain measure of privileges and immunities from the jurisdiction of the territorial state. They require these immunities to carry out their duties properly. Since no precise customary rules exist on the subject, these immunities and privileges have been accorded to them under international agreements. Privileges and immunities under the agreements between international organizations and the host state have been extended even to the regional and field offices as well as special rapporteurs of these organizations. The extent of privileges and immunities granted to representatives, delegates, and observer missions to international organizations are at par with diplomatic agents as stated in the 1961 Vienna Convention on Diplomatic Relations. The convention is not yet in force. Before we end our program, we have one last topic to discuss. That is diplomatic and consular relations. States normally conduct their mutual relations at the international level through diplomatic missions that are accredited permanently by a state to other countries. Diplomatic envoys are the authorized agents to help states in performing the acts of diplomacy, maintaining mutual relations, communicating with each other, or carrying out political or legislative transactions. Diplomatic missions provide an important link between the country which sends them and the country to which they are accredited. The 1961 Vienna Convention on Diplomatic Relations declares that the establishment of diplomatic relations between states and of permanent diplomatic missions takes place by mutual consent. Under customary international law, diplomatic missions have three functions to perform: to protect the interests of the sending state and its nationals, to negotiate with the government of the receiving state, and to report about the conditions of the receiving state. There are three categories of heads of mission, namely, ambassadors or legatees appointed by the Pope accredited to heads of state, and other heads of mission of equivalent rank, ministers, envoys, and internuncios accredited to heads of state, chargés d'affaires accredited to ministers for foreign affairs. Whereas ambassadors and legatees are the diplomatic agents of the first category and considered to be representing the person of their sovereign, chargés d'affaires are diplomatic agents of the last category. The convention provides that except for precedence and etiquette, there is hardly any distinction between diplomatic agents with regard to their privileges and immunities. States conduct diplomatic functions in the territory of the receiving state with its specific permission. This entitles diplomatic missions and their staff to certain privileges and immunities and enables them to function smoothly. So, this is the end of our program for Chapter 5 of the Public International Law course. Goodbye, and don't forget to watch our next program, Chapter 6.